The court will calculate support using the payer's total income, including corporate dividends, deferred compensation, and offshore holdings. That was the sentence that made my father-in-law grip the edge of the boardroom table until his knuckles turned white. But I'm getting ahead of myself. The morning his lawyer called me, I was standing in the parking lot of CFB Petawawa, holding a cardboard box of personal effects. Honorable discharge. 12 years in the Canadian Armed Forces, deployments to Latvia, Mali, and Iraq, strength training in -40 winters, nights spent monitoring radar screens in places I still can't name. I'd given everything to my country, and walked out with a box that weighed less than my rucksack. My phone buzzed. Unknown number, 416 area code, Toronto. Miss Tremblay, this is David from Hargrove Partners. Mr. Richard Segal would like to arrange a private meeting regarding a personal family matter at his earliest convenience. Not his son, not my husband. A lawyer from a Bay Street firm I'd heard mentioned once on the CBC. I knew immediately what this was about. His son Jonathan and I had been married for just under 2 years. We'd met at a fundraiser in Ottawa. He was charming, self-deprecating in that way men raised around generational wealth sometimes are when they're trying to seem ordinary. He made jokes about his father's wine collection. I made jokes about eating ration packs in the desert. We balanced each other, or so I thought. When I told Jonathan I was pregnant, he didn't celebrate. He didn't panic. He just went very still, the way a deer freezes before bolting. That silence should have told me everything. 3 days later, I was sitting across from Richard Segal in his corner office on the 52nd floor of a Bay Street tower, floor-to-ceiling glass. Lake Ontario gray and flat in the distance. The carpet was the color of old money, dark, quiet, absorbing sound. He stood when I entered. Mid-70s, silver-haired, immaculate posture. The kind of man who shakes your hand firmly and holds eye contact 1 second longer than comfortable. "Corporal Tremblay," he said. "I haven't been corporal in 6 weeks," I replied. We sat. He didn't waste time. He slid a leather folder across the glass desk. Inside was a certified check for $6 million, already signed, attached to a separation agreement, and a non-disclosure clause that ran 18 pages. "There's also a medical referral," he said. "A private clinic in Montreal. Discretion has been arranged." Discretion. That's the word he used for my child. "I assume Jonathan has spoken with you," he continued. "Our family is navigating several corporate transitions. His involvement in the Segal Foundation board and 2 pending acquisitions makes this an inopportune moment for personal complications. Personal complications. I've carried soldiers on my back through smoke. I've held the hand of a 19-year-old from Winnipeg while a medic tried to stop the bleeding. Don't talk to me about complications." "What exactly are you asking me to do?" I said. He met my eyes without flinching. "I'm offering you financial security. $6 million, immediate wire transfer, in exchange for confidentiality and resolution." Resolution. He meant erasure. "You're asking me to terminate the pregnancy and walk away from the marriage. I'm asking you to consider the long-term stability of everyone involved." That's when I smiled. Not because anything was funny. In the military, when someone underestimates your position, you don't correct them. You let them keep talking. $6 million? I asked. "It's more than generous." I nodded slowly. "All right." Something shifted in his expression. Relief. He thought I was practical. He thought I understood where I fell in the hierarchy of his world. "Very sensible," he said. Sensible. He had no idea who he was sitting across from. I took the folder and left. On the street below, Bay Street hummed with the usual lunchtime crowd suits, briefcases, the occasional cyclist weaving between cabs. The wind off the lake cut through my jacket. I stood there for a long moment, holding a check for $6 million that I had no intention of ever depositing. That night, I didn't call Jonathan. I didn't cry. I sat at my kitchen table in the 1-bedroom apartment I was renting in Ottawa and pulled out a business card. A woman I'd served with a sergeant from Valcartier had gone through a brutal custody fight after her deployment ended. She'd given me her lawyer's name 2 years ago, just in case. Her words exactly. The lawyer's name was Catherine Morin. 61 years old, former Crown prosecutor, fluently bilingual, with a reputation in Ontario family law that preceded her the way smoke precedes fire. Calm, methodical, devastating in court. She answered on the second ring. I was offered $6 million today to end a pregnancy and disappear, I said. She was quiet for exactly 4 seconds. Are you safe? Yes. Do you want the child? More than anything. Another pause. When can you come in? The next morning I was supposed to be in Montreal at the private clinic Richard Segal had arranged. Instead, at 8:30 a.m., I sat in Catherine Morin's office on Elgin Street in downtown Ottawa. The walls were lined with family law textbooks and framed letters of commendation. She read the separation agreement page by page, her glasses perched on her nose. They're asking you to waive all claims to spousal support, child support, property division under the Family Law Act and future disclosure, she said. And this NDA, this is extraordinarily broad. It prevents you from ever speaking about the marriage, the pregnancy, or any member of the Segal family in any context. He thinks it's generous, I said. She looked at me over her glasses. Do you want $6 million? I want my child protected. She leaned back. Then you don't sign this. You file first. Explain. Under Ontario's Family Law Act, once you establish that you're a spouse, which you already are, your married child support is calculated using the federal child support guidelines based on the payer's income. For someone at Jonathan's income level, including trust distributions, dividends, and corporate compensation, the guideline amount alone over 18 years will significantly exceed $6 million. And that's before Section 7 expenses. Section 7? Special or extraordinary expenses. Private schooling, childcare, medical costs, extracurriculars, those are added on top of guideline support, proportional to each parent's income. She slid a printed guideline table across the desk. And here's the critical piece, she said. If we file in Ontario Superior Court before they attempt to push this into private mediation or arbitration, it stays under judicial oversight. Public record. Enforceable. They can't bury it. That's what this is about, I said. That's what it's always about with families like this. They want to control the forum. We take that away. She closed the folder gently. So, she said, what would you like to do? I thought about every formation I'd ever stood in. Every time I'd been told to hold my position, even when the ground shook underneath me. I thought about one heartbeat inside me that had done nothing wrong and deserved more than a check and a silence clause. File, I told her. She gave me a small nod. Good. Tomorrow morning, we walk into court. And somewhere in Toronto, a man who had built his empire on controlling outcomes was about to discover that Ontario family law doesn't care how many buildings have your name on them. The morning I was supposed to be at a private clinic in Montreal, I was standing in line at the security entrance of the Ontario Superior Court of Justice in Ottawa. The hallway smelled like floor cleaner and recycled air. Fluorescent lights, plastic chairs, a vending machine humming in the corner. No marble floors, no corner offices with lake views, just ordinary Canadians waiting their turn. A young father reviewing a parenting schedule, a grandmother clutching a stack of report cards. A woman in scrubs staring at a notice of motion like it was written in code. This was real life. Catherine stood beside me in a navy blazer that had seen more courtrooms than I'd seen deployments. She carried a slim briefcase and the composure of someone who understood procedure the way I understood tactical planning. You're certain? She asked quietly. I nodded. I didn't grow up with money. I grew up in Timmins, in a house my grandfather built after coming home from peacekeeping in Cyprus. We didn't waste food. We didn't waste words. And we didn't walk away from responsibility. Catherine reviewed the documents one final time. Application for child support under the Divorce Act and Family Law Act, she said. Motion for financial disclosure under Rule 13. Request for interim support pending full hearing. Filing date, today. Once it's filed, I asked. It's before a judge. They can't redirect it into private channels. We're under the jurisdiction of the Superior Court of Ontario. That was the part Richard Segal hadn't planned for. Men like him operate in controlled environments, boardrooms, private mediation suites, negotiation tables with NDAs stacked like sandbags. They avoid courtrooms the way I used to avoid uncleared roads. Public record changes the power dynamic entirely. Catherine handed the clerk the paperwork. The clerk typed, reviewed, and stamped. That sound, the heavy thud of a court stamp, was louder than any check sliding across a glass desk. Outside, Catherine called a process server. They'll be served at the Toronto residence today, she said. I almost felt sorry for whoever had to interrupt Richard Segal's morning meeting. Almost. As we walked along Elgin Street, Catherine explained what would follow. In high-income cases, she said, child support in Canada isn't symbolic. Under the federal child support guidelines, the table amount is calculated based on the payer's gross annual income. Above $200,000, the court uses a formula, and for incomes like Jonathan's, we're talking salary, bonuses, trust distributions, dividends, stock options. The annual support obligation alone is substantial. And if they try to underreport, the court can impute income. Judges don't appreciate games. That was the other thing Richard Segal had miscalculated. He assumed I wanted a quick payout. $6 million sounds enormous. To most Canadians, it is. But over 18 years, childcare, schooling, healthcare, university tuition, structured savings, the number shifts. More importantly, a court order is enforceable. A one-time payment buys silence. A court order creates accountability. When I got back to my apartment, my phone lit up. Jonathan. I let it ring twice. What have you done? He asked. His voice wasn't angry. It was rattled. I filed. You were supposed to. He stopped. Disappear quietly? Silence. You don't understand, he said finally. My father is trying to protect the business. I'm trying to protect our child. We could have handled this privately. No lawyers, no court. You mean on his terms? He exhaled slowly. He thinks this will become public. It already is. Another silence. Long enough that I could hear traffic on his end, the sounds of a Toronto street. I didn't want this to get ugly, he said. It doesn't have to be. But it will be legal. That distinction matters. After we hung up, I sat at my kitchen table and placed both hands on my stomach. 10 weeks. No visible change, just a heartbeat confirmed on an ultrasound screen 2 weeks earlier. I thought about the offer again. $6 million. For someone who grew up where I grew up, that figure feels like a different life entirely. But I've seen what happens when people accept the easy payout. No structure, no oversight, no guarantees. And children born into wealth disputes, especially children whose existence is treated as inconvenient, deserve guarantees. That afternoon, Catherine called. They've been served. How did he react? According to the process server, she paused, he went white. I closed my eyes. That wasn't satisfaction. It was confirmation. For the first time, the situation was outside his control. The hearing date would be set within weeks. Financial disclosure deadlines issued. No more quiet arrangements, no assistant phone calls, just a judge in a black robe and Canadian statutes that apply equally to a factory worker in Hamilton and a billionaire on Bay Street. That's something people forget. In this country, the law doesn't vanish because you've grown accustomed to influence. That evening, I received a single text message. Not from Jonathan, from Richard Segal himself. 3 words. This is unnecessary. I didn't respond. Sometimes the most powerful answer is process, and for the first time since that leather folder slid across the glass desk, I felt calm. Not because I had won, because I had chosen the right ground. The first official court notice arrived on heavy paper with the coat of arms of Ontario embossed at the top. It wasn't dramatic, it wasn't cinematic. It was procedural. But procedure is power. Catherine called the afternoon it was issued. Preliminary conference is set, she said. 3 weeks. That's fast. They requested an adjournment. The judge declined. I allowed myself a slow breath. For men like Richard Segal, delay is a weapon. Postpone, exhaust, negotiate behind closed doors until the other side runs out of patience or money. But once we filed first, we set the tempo. That night, Jonathan showed up at my apartment unannounced. He looked different, not polished, not composed, tired. You blindsided us, he said quietly. I filed an application. That's not a blindside. That's how the system works. My father's board is asking questions. About what? Responsibility? He ran a hand through his hair. You don't understand how these things work. I understand exactly how they work. That's why I filed. He looked at me then, and for the first time he didn't see an inconvenience. He saw someone he had underestimated. I would have taken care of you, he said. That's the problem, I replied. I don't need to be taken care of. This child needs to be protected. There's a difference. He sat down heavily on a kitchen chair. My father says you're making a mistake. Your father offered me money to erase his grandchild. He thought he was being practical, So did a lot of men who regretted it later. He didn't argue after that. The following week, Catherine and I prepared. She explained what would happen in calm, precise terms. The judge will address financial disclosure first. Under Rule 13, both parties must produce sworn financial statements. Income tax returns, notices of assessment, corporate financial statements, trust documents. If they resist, they can't. Not legally. I asked her something that had been on my mind since that first meeting on Bay Street. Why did he go white? She didn't hesitate. Because once this is before a judge, child support isn't negotiated by ego. It's calculated by guideline. And with Jonathan's income profile, salary, trust distributions, stock options, dividends, she slid a printed calculation across her desk. The projected total over 18 years was significantly more than $6 million. Before Section 7 expenses, before university contributions, before any consideration of spousal support. He thought he was capping his exposure, she said. Instead, he triggered full financial disclosure. Think of it as an audit, not revenge. Audit. The case conference arrived on a gray February morning. Family court in Ottawa isn't glamorous. The rooms are small, the chairs standard government issue, the air dry from old radiators. When Richard Segal entered, he wore a charcoal suit tailored to the millimeter. His legal team followed 2 senior partners from a Bay Street firm and a junior associate carrying document boxes. He didn't look at me. Jonathan did. The judge, a man in his early 60s with careful eyes and a measured tone, reviewed the filings. Application for child support and spousal support, he said. Motion for financial disclosure. Under Rule 13. Request for interim support. He looked up. Is paternity in dispute? One of the Segal attorneys stood. No, Your Honor. No theatrics. No drama. Just acknowledgement. The judge ordered full financial disclosure within 21 days. Then he addressed the scope. Given the income representations, he said calmly, the court requires complete documentation of salary, bonuses, trust income, corporate dividends, stock option exercises, and any other sources of revenue. I watched Richard Segal's jaw tighten, almost imperceptibly. For a man accustomed to total privacy, disclosure feels like exposure. For a court, it's routine. We will comply, his attorney said. The judge nodded. This court's primary concern is the welfare of the unborn child. All motions regarding private arbitration or mediation in lieu of court proceedings are denied. Denied. That word settled in the room like a door closing. After the conference, Richard Segal approached me directly for the first time since Bay Street. You've made this far more complicated than it needed to be, he said evenly. No, I replied. I made it transparent. You could have walked away comfortable. I still will. He held my gaze longer than before. You forced exposure. I forced accountability. For a moment, something flickered across his face. Not anger, recognition. He wasn't dealing with someone intimidated by wealth. He was dealing with someone trained to hold ground under pressure. As he turned away, I heard one of his attorneys murmur, "This is going to be expensive." Expensive. As if a child is an expense report. Catherine touched my arm gently. You handled that well. I didn't handle anything, I said. The court did. And that's when I understood clearly why filing first mattered so much. Had I gone to that clinic in Montreal, there would be no court record, no structured support, no legal protection for a child who hadn't yet taken a first breath. Instead, there was now a court file number, a judge, a statutory framework, a process bigger than any one man's checkbook. That evening, Catherine called with an update. Financial disclosure is due in 21 days, she said. If they delay, we bring a motion to compel. I stood by my apartment window, watching the snow fall on Elgin Street. I didn't feel triumphant. I felt steady. This wasn't about proving a point. It was about setting a foundation for my child, for myself, and perhaps even for a man who had spent his life believing money could resolve anything quietly. The billionaire had gone white because he realized something simple. He could control boardrooms, he could influence markets. But he could not control the Family Law Act. And the Family Law Act had just walked into his world. The financial disclosure documents arrived in stages. Income tax returns, notices of assessment from CRA, corporate financial statements, trust summaries, stock option records. The numbers were substantial. Even conservatively calculated, Jonathan's gross annual income placed him well above the highest tier in the federal child support guidelines. Catherine walked me through it in her office, line by line. Under the guidelines, she said, table support is calculated as a percentage of gross income. For incomes above $150,000, there's a formula. At Jonathan's level, the annual guideline amount alone is significant. And that's before we add Section 7 expenses, childcare, medical, educational. Meaning? I asked. Meaning this child won't live modestly while their father lives extravagantly. That's the principle. Children are entitled to benefit from the standard of living of both parents. $6 million suddenly looked small. Jonathan called that evening. This is spiraling, he said quietly. No, I replied. It's stabilizing. My father's board is asking about the disclosure language. I'm thinking about pediatric care and RESP contributions. He sighed. You're enjoying this? I paused. No. I'm enduring it. There's a difference. A week later, we attended the financial disclosure review before the judge. No drama. Just paperwork and deadlines. The judge reviewed the sworn financial statements. Mr. Segal's compensation includes salary, annual performance bonuses, trust distributions, stock option exercises, and corporate dividends, he noted. He looked directly at Jonathan. Are these figures complete and accurate? Yes, Your Honor. His father shifted slightly in the row behind. The judge continued. Given the income level and the projected long-term support obligation, the court will order interim support pending final determination. Interim support. Structured. Enforceable. Jonathan's attorney attempted to redirect. Your Honor, the parties had previously explored a private resolution. The judge raised a hand. This court prioritizes the best interests of the child. Private arrangements do not override statutory obligations under the guidelines. Statutory obligations. Law over leverage. As we left the courtroom, Richard Segal addressed me one final time. You've ensured maximum visibility, he said. I've ensured maximum protection, I replied. You could have handled this discreetly. I could have handled it invisibly. There's a difference. For the first time, he didn't counter. He studied me. I underestimated you, he said. Yes, I answered. You did. That wasn't pride. It was fact. In the days that followed, something unexpected began. Jonathan started asking practical questions. What kind of pediatrician are you looking at? Have you thought about childcare options for when you return to work? What about a parenting schedule? These weren't defensive questions. They were participatory. Pressure reveals character. His father had responded to pressure with control. Jonathan, under the same pressure, began responding with responsibility. Catherine noticed it too. He's adjusting, she said. Sometimes it takes structure to clarify priorities. One afternoon, I received an unexpected call. Not from Jonathan, from Richard Segal himself. I'd like to meet, he said. In what capacity? As a grandfather. That word hung in the silence. Grandfather. Not liability, not scandal. Grandfather. We met at Catherine's office, neutral ground. He arrived without his legal team. He looked older, not frail, reflective. I built everything from nothing, he began. Arrived in this country at 22 with $600 and a degree no one here recognized. I spent 50 years building and protecting what I built. I understand protection, I said. But I confused control with protection, he admitted. That surprised me, he continued. My instinct was to eliminate risk. And my instinct was to protect my child from being eliminated. Silence settled between us. Then he said something I hadn't expected. I was wrong to treat your child as a problem to be solved. That was the first genuine shift. Not financial, personal. We discussed structure, RESPs for education, healthcare provisions, estate planning adjustments that formally acknowledged the child. Nothing dramatic, just responsible, Canadian, methodical. As he stood to leave, he paused. You filed first, he said quietly. That forced my hand. Yes. And perhaps, he added, it forced clarity. When the door closed behind him, Catherine looked at me thoughtfully. Pressure doesn't always break people, she said. Sometimes it reshapes them. Walking home through the Byward Market that evening, snow crunching under my boots, I felt something unfamiliar. Not victory. Balance. The case wasn't over. Final calculations still lay ahead. Custody arrangements still needed drafting, but the tone had shifted. Not because anyone surrendered, but because structure had replaced secrecy. The final support hearing arrived in late spring. I was 7 months pregnant. The baby was no longer an abstraction. She kicked at night. She shifted when I tried to sleep. She reminded me, constantly and quietly, what this had always been about. The courtroom looked the same as it had months earlier. Same institutional chairs, same muted hallway conversations, same radiator hum. But the atmosphere had changed. Disclosures had been verified. Income confirmed. What had been speculation was now fact. The judge reviewed the file. Paternity acknowledged. Financial disclosure verified. No dispute as to income accuracy, he summarized. Then he began the calculation. Under the federal child support guidelines, child support is determined based on the payer's gross income. For high-income earners, the court applies the formula in the guidelines and may exercise discretion to ensure the child benefits proportionally from both parents' standard of living. He walked through it methodically. Guideline amount. Section 7 expenses, childcare, healthcare, education, life insurance requirement to secure the support obligation, RESP contributions, trust provisions for long-term security. The projected 18-year total exceeded the original $6 million offer by a wide margin. Before university tuition, before discretionary enhancements. Jonathan swallowed visibly. Richard Segal's expression remained composed, but his hands were very still in his lap. The judge then addressed custody. Have the parties discussed a parenting arrangement? Jonathan stood. Yes, Your Honor. We're proposing shared decision-making responsibility and a structured parenting schedule, initially supervised, expanding as appropriate. He glanced briefly at me. I nodded. Catherine stood. My client agrees, subject to enforceable terms and a review mechanism. The judge approved the framework subject to a final written agreement. Then he said something that stayed with me. A child is not a financial inconvenience. A child is a legal and moral responsibility. This court exists to ensure that responsibility is honored. That sentence hung in the air longer than any number discussed that morning. When proceedings concluded, the interim order converted to a final order, structured monthly support. Trust contributions earmarked for education and healthcare. Enforceable, transparent, secure. Outside, the hallway was quiet. No reporters, no cameras. Just paperwork and consequences. Jonathan approached first. I should have handled this differently from the beginning, he said. Yes, I replied. Not harshly, just truthfully. I was afraid, he admitted, of my father, of the board, of looking irresponsible. And now? Now I'm more afraid of being absent. That was growth. Not dramatic. Not cinematic. Just real. Richard Segal approached last. He looked at me for a long moment. I misjudged what strength looks like, he said. Strength isn't silence, I answered. No, he agreed. It isn't. He extended his hand. Not as negotiation, as acknowledgement. I shook it, not because everything was resolved emotionally, but because accountability had been established legally. My daughter was born on a clear October morning at the Ottawa hospital. No press, no announcements. Just hospital bracelets, soft blankets, and a cry that sounded stronger than anything that had happened in a courtroom. Jonathan was there. He stood awkwardly at first, unsure where to put his hands, unsure how to hold something so small after a lifetime of managing things so large. When the nurse placed her in his arms, something shifted in his face. Not calculation. Recognition. Richard Segal arrived that afternoon. No entourage, no assistant. Just a man in his 70s carrying a small stuffed moose in a gift shop bag from the hospital lobby. He stood at the foot of the bed and looked down at his granddaughter. She's smaller than I imagined, he said quietly. That's how they start, I replied. He stepped closer. May I? It was the first time he had asked permission since I'd met him. He held her carefully, almost formally, as if she might judge him. Hospitals strip away hierarchy. In that room there were no board seats, no stock options, no 18-page NDAs. Just 3 adults and 1 newborn. Later, when Jonathan stepped out, Richard remained by the window overlooking the Rideau Canal. I've spent 50 years building control, he said without turning around. And I nearly destroyed something irreplaceable trying to maintain it. You offered me $6 million, I said. Yes. To erase her. I believed I was preventing scandal. You were preventing responsibility. He nodded once. That is true. No defensiveness. Only weariness. He turned to face me. When you filed, he said. I was furious. I know. I went white because I realized I wasn't negotiating anymore. I was answerable. Answerable. That was the word he'd never used before. I confused authority with immunity, he continued. They're not the same. No, I said. They're not. He walked back to the bassinet and looked down again. I've instructed my lawyers to revise my estate plan, he said. She'll be named as a direct beneficiary, not through Jonathan, directly. You don't have to do that, I said. I know. Silence settled gently. I was wrong, he said again, softer. There's a weight to hearing those words from someone who rarely says them. I didn't file to punish you, I said. I understand that now. He adjusted the blanket around her shoulder with unexpected care. I built my life believing every problem disappears if you write a large enough check, he said. You showed me something different. I didn't show you, I replied. The law did. He allowed himself the smallest smile. Yes, he said. It did. It's been 5 years now. My daughter is in senior kindergarten at a public school in the glebe. She argues about which boots to wear in the snow and insists on zipping her own coat, even when the zipper catches every time. She doesn't know anything about Bay Street offices or non-disclosure agreements. She doesn't remember a time before stability. That's exactly the point. We live in a modest townhouse in Centertown, not extravagant, not headline-worthy, just stable. Jonathan moved 3 blocks away when she turned 2. Shared parenting became routine. Wednesday dinners, alternating weekends, school concerts attended without tension, skating at the canal on Sunday mornings. The court order remains in place, quietly doing its job. Automatic transfers, RESP contributions, healthcare coverage, life insurance naming her as beneficiary. No drama, just consistency. Richard visits every other week. He arrives without announcement now, usually carrying something small, a library book, a puzzle, once a miniature hockey stick he'd had custom engraved with her initials, which she immediately used to push a ball around the living room with far more enthusiasm than technique. The first time she called him Grandpa, he froze. Not in discomfort, in recognition. I saw it in his eyes, the weight of what almost didn't exist. One evening after she was asleep, he and I sat at the kitchen table with cups of tea. No legal binders, no folders. No offers sliding across polished surfaces. I used to believe privacy meant strength, he said. And now? I asked. Now I understand transparency is what holds families together. He set his cup down carefully. I can't undo what I tried to do, he continued, but I can decide who I am going forward. That's all any of us can do, I replied. The Veterans Child Care Fund he established last year operates quietly. No press conferences, no gala dinners, just funding for single service members across Canada who struggle to balance duty and parenthood. He named it after his own mother, who raised 3 children alone after arriving in Montreal from Eastern Europe in 1962. Catherine still reviews the trust documents once a year. She calls it preventive law. I call it peace of mind. The $6 million check expired in my desk drawer. I never deposited it. It represented silence. The court order represents security. And over time, even Richard began to acknowledge that security is worth more. On my daughter's 5th birthday, we gathered at Jonathan's apartment. Balloons, a homemade cake, no photographers. Richard knelt carefully on the hardwood floor in his pressed trousers while my daughter placed a paper crown on his head and declared him the king of birthdays. He didn't correct her. He laughed. That sound was new. Not polished, not controlled, just human. Later that evening, as the guests left, he stood beside me near the door. You were right to file first, he said quietly. I was right to file for her, I corrected. Yes, he agreed. You were. There are moments when revenge would be easy. Public humiliation, financial escalation, media exposure. But I've learned something over years of service, and over years of living. The most powerful form of justice isn't destruction, it's correction. The billionaire went white because he believed he was losing control. What he was actually losing was illusion. And sometimes losing illusion is the first step toward becoming something better. If you're listening to this and you've ever been pressured into silence financially, emotionally, or otherwise, know this. Structure is not aggression. Accountability is not revenge. And protection is not selfish. It's responsible. My daughter doesn't know the details of how her life began in a courtroom. She just knows she is wanted legally, emotionally, fully. Richard Segal still moves with measured precision. But when my daughter runs into his arms at the door, he doesn't calculate, he holds. That's the difference between control and connection. If this story resonates with you, if you've ever faced a moment where doing the quiet right thing felt harder than taking the easy payout, I hope you carry that with you. Share it with someone who might need the reminder. And if you believe that stories about responsibility, dignity, and standing your ground still matter in this country, consider subscribing and staying with us. Because sometimes the most powerful victories aren't loud, they're structured, they're steady, and they endure.